I told my staff, like, we were talking
Really? Oh, yeah, that's really nice. I'm glad they said that. It was awesome. I love those ladies. Like, just kind of buffered and, yeah, it was awesome. Send picture was really nice to me. She was on Congress.
Yeah, she's,
Really helpful.
yeah, she's still nice.
Yeah. Are you from Nebraska?
No, Florida.
I'm Florida.
But it's her birthday.
Nice. That's great. I'll send her a note. Yeah.
Yeah,
where she always like,
she's a branch off.
Yes.
Correctly.
Yeah, Valentine. I still haven't forgotten my
Oh, I looked at. I wanted to go too, but then I looked on the map. I'm from Canada. That Valentine's way out.
I know it's hard to go to.
Yeah, exactly. Are you still doing field stuff?
Yeah.
Oh, it's still.
Yeah, I'm on my third year, and then before I was with Steve's.
Wow. Oh, nice.
Yeah.
Yeah. Okay.
But now he's with Chamber.
Okay. Oh, nice.
And then it's
That's awesome. Do you want to do that after, right?
someone actually approached me.
You mean at least 3?
Okay.
All 5. There you go.
That's great.
Last week.
Yeah. So I remember when I was construction. Yes, that's what we're going to do for fires and law school. It was awesome. Some of them ended up for a while and really going on. Joining leadership and stuff. Yeah, anytime. I'm happy to help. But, yeah, no, some of my friends are out there now. So it's,
Well, that's great. I hadn't really.
one more. Oh, man, I'm glad I paid off the right people. So.
Please look at it.
Oh, okay. All right.
Thanks again.
Yeah, no time. Do a live stream. Yeah, go absolutely. Yeah.
That's kind of.
Yeah.
Also, Mary's our vice president, and she's
Oh, okay.
with Senator Cruz right now.
Oh,
On
yeah.
judiciary.
Yeah, that's great.
Yeah.
So you guys have a lot of bases covered.
Yeah.
Oh, thank you. Thanks. Yeah. Yeah, I forgot to bring the big mug. Yeah.
All right, folks, thank you so much for being here. I really appreciate it, especially considering that we have midterm season going on. It's a busy week. It's middle of the semester. It's almost spring break. And we are honored. We do have some pizza to go ahead. We have some pizza pie for Chairman Pie.
Been waiting all week for
I
that.
have been. I've been a year for this. So let me go ahead and introduce Mr. Ajit Pai. He is a former chairman of the Federal Communications Commission and a non-resident fellow at the American Enterprise Institute. And there he focuses on issues pertaining to technology, innovation, telecommunications regulatory policy, and market-based incentives for investment in broadband development. Concurrently, he is also a partner at Searchlight Capital Partners, which is a global investment firm. Mr. Pai's distinguished career at the FCC includes 2 leadership roles following presidential appointments. He was appointed commissioner by President Barack Obama in 2012, designated chairman by President Donald Trump in 2017, and twice confirmed by the United States Senate. While at the helm of the FCC, Mr. Pai had a transformative effect on the future of US technology and telecommunications policy, implementing major initiatives to help close the digital divide, advance US leadership in 5G and other wireless technologies, promote innovation, protect consumers, public safety, and national security, and make the agency open, transparent, and data-driven. Earlier in his career, Mr. Pai served in various public sector positions in the FCC's Office of General Counsel, the U.S. Department of Justice, the U.S. Senate Judiciary Committee, and the U.S. District Court for the Eastern District of Louisiana. He also works as a partner at Jenner & Block and Associate General Counsel at Verizon Communications. Mr. Pai graduated with honors from a small college you may have not heard of called Harvard University, where he received his bachelor's degree, and from UChicago Law, where he received a law degree and was an editor on the University of Chicago Law Review. It is a privilege to introduce Mr. Bai.
Well, thank you very much, Ellie, for that very kind introduction. Yeah, I wish my mother would introduce me as quickly as she did. She's still hoping I go to medical school, I think, to make something of myself. But anyway, I want to thank the chapter for hosting this lunch today, and thanks to all of you for coming. I didn't realize you were in the middle of midterms, so I know that's opportunity cost there associated with being here today. But it's great to be back, and it's sort of a timely time to discuss some of the topics that I was asked to discuss. And I'll have a few minutes of remarks, but certainly would welcome any questions you have about anything under the sun. It could have to do with Section 230 or China and 5G, net neutrality, whatever it is. Love to have a robust Q&A discussion. So the immediate topic that was on my mind involved Section 230. And as you might have seen last week, the Supreme Court heard two cases that involved various aspects of Section 230. Day one involved a case with Google and YouTube, in which a family of somebody who was killed in a terrorist attack sued YouTube, arguing that Google had applied algorithms that essentially enhanced the prominence of certain ISIS-related content, and thus they should lose some of their liability under Section 230 for protection, which gives them, generally speaking, immunity as a publisher, from being a publisher. And the next day they heard a case involving Twitter. In the case, it was similar facts. A terrorist victim's family sued under an anti-terrorism law. And the question there was whether essentially Twitter had done enough to remove certain terrorist-related content that they argued was somewhat related to the terrorist attack in question. And so you heard, if any of you heard the oral arguments, you heard the justices of all stripes kind of struggling with not just the question of liability, like what was the connection between the terrorist attack and the particular content on these platforms, but also what exactly it means to be a publisher on the internet. What does Section 230 have to say in 2023 that it might not have been evident to say in 1996? And to me, the Google case was actually quite interesting. So there, essentially what the counsel was arguing, they had ceded certain parts of their argument, but what the plaintiffs were arguing in that case was essentially that Google was applying algorithms that created thumbnails, and then people who search for ISIS content could click on those thumbnails relatively easily, compared to sort of a neutral platform in which they would have to actually go and hunt down those videos. And the counsel's argument was, look, we understand that Google is not a publisher of those videos. They didn't create the videos. They didn't have any particular knowledge about those videos. But what they did do was establish an algorithm that enhanced the prominence beyond what otherwise would be the case of those videos. And thus, they argued that YouTube should not be immune under Section 230. And the particular section of Section 230 is 230C1, and actually printed out the statute. So I think it's always helpful to have the law in front of you when you're trying to talk about the law. And that statute says, as you might know, no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. And so the question the justices were struggling with was, yes, Google has this algorithm. They do apply it. It does create these thumbnails. In some cases, it might even enhance the prominence in the search results of certain content. But does that make it actually a publisher? And there's not an easy answer to that question. If you think about it, you could argue, yes, on one hand, Google is publishing in the sense that it's applying its special sauce, its algorithm, to create something that otherwise consumers probably wouldn't see. Like they might not ever see this ISIS content if the algorithm didn't highlight it and create a thumbnail. On the other hand, as Justice Kagan was pointing out, these are algorithms that are sort of neutrally applied. I mean, you could put in ISIS, but you could also put in cat videos or whatever, and Google's algorithm would yield a certain result. It would yield a series of thumbnails that were kind of responsive to whatever your search was. And so it wasn't Google speaking in the same sense you would think of a publisher doing. They weren't sort of publishing an op-ed or an editorial in a newspaper. They were simply applying an algorithm to any content that's on the YouTube platform. So I'm not sure exactly what the justices are going to do in this case. It's a sort of very unusual case given the facts. I tend to think that they're probably not going to find that YouTube loses Section 230 liability, but it's sort of it's really a guess. I mean, you saw justices, as I said, on both sides of the ideological spectrum, making different arguments. And at one point, Justice Kagan kind of captured the zeitgeist of the court, I thought, when she said, on one hand, I think I'm almost quoting here, that every other industry has to internalize the cost of its conduct. Why should the tech industry get a pass? And that's something that underlies a lot of the concern about Section 230, that's sort of giving the tech industry a special immunity that no other industry gets. On the other hand, she followed it up by saying, now look, we are just a court. We are not the 9 greatest experts on the internet, which is sort of a statement of judicial restraint that I think a lot of the justices were very wary of. They don't want to sort of change the statutory interpretation in such a way that's going to upend almost 3 decades now of the commercial internet experience for most people. So there, I'm not quite sure what the court's going to do, but I think there's a better chance than in the Twitter case, which I'll get to in a second, that the court will find that there is sort of a little bit of wiggle room to compromise Section 230 liability. The Twitter case is, to me, not as interesting, and that's generally speaking because of the facts involved. So in this case, again, a terrorist victim whose family was suing under an anti-terrorism statute involving aiding and abetting liability. And the question to the court in that case was, did Twitter do enough to remove certain content that was related to terrorist content on the platform? And there it's sort of weird because Twitter has a policy of removing certain content that's related to ISIS or otherwise threatens terrorist or violent harm. But the question is, in this case, they didn't remove particular videos involving ISIS that the plaintiffs said were related to the terrorist attack. On the other hand, Twitter didn't know about the specific terrorist attack in question, of course, didn't directly provide affirmative assistance to the terrorists in providing the platform. And so it's sort of a weird case. And there you heard the justices asking you about essentially the attenuation between the terrorist attack and the plaintiff, Twitter's content. Does Twitter have to know who's using the platform? Do they have to apply the policy in every single case in order to get liability protection? How substantial does the knowledge have to be? Like, what exactly do they have to know? Do they have to know, for example, that members of ISIS are using the platform? They pretty much knew that. There's evidence in the record that suggests they know that there are people out there that ISIS is using to organize activity on Twitter. But they didn't know about the specific act. They didn't know when it was going to happen, who was going to do it, that the plaintiff was ultimately going to suffer, of course. And so there's a big question about causation that I think is interesting as a legal matter, but not really as a Section 230 matter. And in this case, again, this comes under Section 230C1 about whether Twitter is a publisher for purposes of Section 230. And here I think it's pretty clear that, I think it's pretty clear that they're not. They didn't publish the content. In fact, they had a general policy of removing content like that. They had removed similar content in other cases. They had allowed some of the content to remain up. And so I think Twitter's attorney, Seth Waxman, himself a former Solicitor General of the United States, I think did a pretty good job of arguing that, whatever Twitter's liability might be in cases where they provide affirmative assistance, they did not provide affirmative assistance here. And so this is not really a publisher case at all. If they have liability, it might be under sort of general tort statutes. And you might have to find another theory of legal liability outside the parameters of Section 230. So yesterday, as Luis was very kind to mention before we started, I was on CNBC and I was asked about some of these cases. Oh, sorry, this is last week. I was asked about some of these cases, and what does this mean for free speech on the internet? And to be honest, Section 230C1, which was what inspired these two cases, is not really the meat, I don't think, about some of these questions about Section 230 that people have been debating for a few years now. The question about whether YouTube is a publisher or Twitter is a publisher is interesting as a legal matter, but I don't think it actually gets to the gist of what a lot of people are upset with the social media companies about. They're mainly upset about the civil liability protection under Section 230C2. And Section 230C2 says that no provider or user of an interactive computer service, essentially a YouTube or Twitter, shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. And as you may recall, during the end of my time at the FCC, President Trump issued a directive to the Department of Commerce to submit a petition to the FCC arguing that Section 230 should be, we should take a look at the interpretation of Section 230 and that we had legal authority to issue rules interpreting the section, and that we should issue rules that were more consistent with a narrow interpretation of those rules, of the statute. And here I think a lot of the concern is, especially from conservatives, is that some of the social media platforms are taking down content and claiming Section 230C2 liability but they don't really avail themselves of they shouldn't be able to avail themselves of that immunity because number one, some people argue that these companies are not taking down content in good faith. And number two, that otherwise objectionable in the statute has become sort of a catch-all. And there's a sort of canon of statutory interpretation that you might be aware of that says that if there's one term that is very general and it follows a bunch of terms that are very specific, the general term should be interpreted in the context of all of those specific terms. And the argument would be in this case that in 1996, Congress did not have in mind otherwise objectionable as like a huge catch-all exception that you could drive a truck through, but mainly they wanted to catch other types of things such as obscene, lewd, lascivious, filthy. They didn't have in mind sort of political decisions. So, for example, if Twitter said, we don't like Democrats, we're not going to allow Democratic content on our platform, and we get Section 230C2 immunity because we find it otherwise objectionable. That's not what Congress had in mind. This is an argument that was advanced by Justice Thomas in a couple of cases, just independent statements. He wasn't writing for the court. And picking up on that thread, you're now seeing some litigation bubbling up in which people are starting to challenge their received orthodoxy about Section 230C2. Should these platforms have Section 230C2 immunity if they decide, for whatever reason, that they just don't like a certain political point of view, or they just target a category that is not included within those specified in Section 230C2? That's a really interesting question. And there, I think there's a decent chance the Supreme Court will take a case. And I think there's a decent chance that they will, in fact, cut back on the interpretation of Section 230, which is essentially giving the tech platforms blanket immunity. And what was interesting to me, quite fascinating, is that if you follow the Google case last week, the Biden Justice Department filed a brief in support of the plaintiffs. However, it also said in a couple of sections of that brief that we agree with Justice Thomas that the interpretation of Section 230 has been overbroad over the years, and that it may be appropriate in another case, not necessarily this one, to look at whether Section 230 should be reinterpreted to more closely hew to the terms of the statute. That to me was really interesting. Why did the Justice Department do it? You wouldn't think the Biden Justice Department would agree with Justice Thomas on much. So the fact that they decided to say that was kind of a signal to me. President Biden himself, as you may know, his official position is Section 230 should be repealed altogether. He said that on the campaign trail. He said it as president. So does that augur the Biden White House making more of a push to either get rid of it altogether or kind of cut back on its interpretation? Time will tell. I just hope I'm around to see the case that comes to the Supreme Court in which they have occasion to ask some of these questions, because you could see some very unusual coalitions. Justice Jackson, in the Google case, for example, is asking a lot of skeptical questions about, aren't you essentially claiming liability from everything? And so it's almost taking a Justice Thomas view of Section 230. So we'll see where it goes. I can't pretend to know what the court is going to do, but it's going to be fascinating as a lawyer and just as an online citizen to see what happens. So anyway, I don't want to drone on for too long. I would welcome any questions you might have about this case or this issue or frankly anything else. But thanks again for having me. Thanks for the introduction, and thanks for the work you're doing for the chapter and for the society. It's great to have a forum that is dedicated to open debate, and look forward to that in the coming minutes and hour. Oh, you don't have to go. Fine. No reason to clap.
I was wondering, what's your opinion on fact finders?
Yeah, so to me that was also interesting. It's like whether or not, as a question of fact, you should allow this case to go forward so you can deduce proof of whether or not Twitter knew or YouTube knew. And that is, I think it was Justice Kagan was asking about that. Like, why shouldn't we allow this to go forward so that you have a discovery process? If you have a jury trial, they can assess whether or not the tech platforms knew. And to me, that's somewhat compelling because assuming the plaintiffs have standing, which I think they clearly do, then it's pretty unusual in the American legal system to say, as a matter of law, you are not allowed to pursue a claim like this, where you are arguing that YouTube knew or didn't know, or how did it apply its algorithm, who did it, all that kind of the meat and potatoes questions that would be involved. And so I was somewhat sympathetic to that. And so I think maybe one out for the court would be to say, we don't need to decide the questions about Section 230 liability. All we need to decide here is on a 12b6 whether or not we should allow discovery to go forward. And that could be an easy out. I can see Chief Justice Roberts led majority saying something like that. We'll bypass the tougher question because we don't want to poke the bear, but what we do want to do is allow the plaintiffs to go forward and see what can they find. And if they find some smoking gun document that says that YouTube purposely applied its algorithm to heighten the prominence of YouTube terrorist content, then we have one set of problems on our hand. But on the other hand, if the plaintiffs can't show anything, then we can just simply dismiss the case at summary judgment. So that would be kind of an interesting procedural vehicle for the court to use, just to say, look, let's let the fact finders decide. Yeah. I personally, as somebody, I kind of hope they don't do that, just because it would be nice to get some clarity on what the court is thinking, but that would certainly be the path of least resistance if I was a justice who didn't want to reach the broader legal issue.
Can you, I remember like, it was a while back when I like saw stuff on Twitter about like net neutrality and things like that. Can you explain that, like, I never like, got into that, so can you explain like just kind of like in general, like what the big ideas of that were?
Yeah, so it's now over 5 years ago, as you might remember, the end of the internet as we know it happened when the FCC decided to remove the Obama-era regulations that applied them. And so essentially in February of 2015, almost 8 years ago, my predecessor at the FCC adopted Title II regulations for broadband providers. And Title II is a part of the Communications Act that essentially construes broadband providers to be common carriers, utilities, if you will. And so with those Title II utility-style regulations come a whole bunch of different regulations. It could be regulated on price, network management, how you manage your network. Essentially, the argument was that we don't want broadband providers to be discriminating on the basis of content. If they don't like the content you're sending or trying to access, they shouldn't be allowed to restrict you. Moreover, they shouldn't be allowed to charge certain websites for faster access to consumers, or you have fast lanes and slow lanes. Another argument was that we shouldn't allow what's called zero ratings. So, for example, if you have T-Mobile and T-Mobile says we will stream music content from YouTube free to you as a service to you, but we won't allow you to stream exempt from any data limits, Spotify or whatever. They wanted to ban that kind of zero rating. And so the Obama-era FCC adopted those regulations in February 2015. We repealed them in December of 2017. And the basic issue from a legal perspective, at least, was, does the FCC have the power both to apply the regulations and then to remove them? And the DC Circuit found that, yes, my predecessor did have the power to adopt Title II regulations. But the same DC Circuit also said in October 2019, the agency also explained adequately why it was removing those regulations. So from an Administrative Procedure Act perspective, they said we followed the standard notice and comment process. And from a substantive communications law perspective, they said that, yes, essentially the Supreme Court, way back in 2003, I think it was, or 2002, in a case called Brand X, said that the FCC can construe broadband providers to be not common carriers or utilities, but what are called information service providers, and information service providers more lightly regulated. There's not a whole panoply of utility-style regulations that apply to them. So we restored that same framework, and as you can see, the internet is still around. It still exists. It's more people are accessing it at faster speeds than ever before, and so to me, at least, the metrics of our decision back then are: are consumers able to access the content of their choice? From a network perspective, the answer is yes. In terms of speeds, our speeds going up today compared to when we made our decision. The average fixed broadband speed in the United States is up 156%. The average mobile broadband speed is up over 300%. And that's in contrast to those who said, if you remember, you can still find this on Twitter, which exists, of course. The Senate Democrat Twitter feed said in this campaign for this week, you will get the internet one word at a time if net neutrality goes away, and that's obviously not the case. It's demonstrably not true. And so, to me at least, I think the decision we made is a successful one. And so the proof is in the pudding now, because it's kind of funny. Tying back to the earlier topic, to the extent that people are restricting content on the internet, it's actually the tech platforms, the very same ones that were pushing net neutrality regulations in the first place, that have now turned around and said, no, we have the right to censor content as we see fit, and we get to Section 230 immunity. So it's kind of funny, under the well-established precedent of goose versus gander, I would argue they should be subjected to the same regulatory burdens they would want to foist on broadband providers if they truly believe the arguments that they're making. But anyway, we'll see where it goes. Right now, the FCC is considering, how, if at all, to move forward. It's a tied commission, 2-2, so most likely these net neutrality regulations wouldn't pass again unless and until there's a fifth commissioner who's sympathetic to them. So we'll see where it goes. But it's kind of funny now. Every now and then, I'll be walking around and it'll come up to me like, hey, aren't you the guy with the mug who did that thing about net neutrality? Like, whatever happened with that? And it's kind of funny. It's kind of receded. And like, there was a real sense, for those of you who remember, like, there's a real sense of panic in the country at the time. Like, the internet is about to end. This guy is like about to take away our access or make us pay more. And it's, I think it's now recognized by people of good faith, at least, as one of the great panics of our time that never really came to materialize.
Yeah. No, I was still like pretty young when it like happened, so I didn't really understand like the whole like all the issues and stuff.
Yeah.
But I definitely think that it was an overreaction for sure.
Yeah, no, every now and then I'll go back and look, and like I kept a list of like all these predictions about what was going to happen, and like I remember 6 ways your life will be more terrible as a result of a G's decision. This is the end of the internet as we know it, from CNN and Bernie Sanders. Each of them said it independently. This is an un-American decision that means that people are going to be kicked offline. Like all of these things, it's just. I remember thinking at the time, like, that's so ridiculous. Like, that's not going to happen, and I know it's not going to happen. It's just going to take time for people to recognize it's not going to happen. So now, at least, I can laugh about it. But at the time, it was pretty serious. Like, people really believed that the internet was coming to an end, and it just wasn't the case. So.
How did you like deal with like having like all like the media pushback and stuff?
I mean, it wasn't easy. The media stuff was fine. Like, I have a pretty thick skin, but it's more that people. Threatening to murder my children, coming to our house, sending unmarked packages, calling my parents at 3 a.m. and cussing them out, just stuff like that really bugged me. And it just, I think this speaks kind of a coarseness in American public discourse these days that, at least I don't remember happening when I was a kid. And now my friends who are in the Biden administration, they get it from the other side too. Like one of my law school classmates was Lisa Monaco, who's the deputy attorney general, and she doesn't go anywhere without a pretty strong security detail because you never know. All it takes is one nut who's pissed off about some decision you made, and that's all it takes. And so, anyway, I don't miss the craziness of that time all that much, but I do like now when people come up to me in the airport and stuff like that, and just say, hey, well, I hated you back then, but now I realize you're not the devil incarnate, and thanks, I guess. I'll take it. So that's to me a sign that people really do, at the end of the day, operate in good faith. They just want the best for themselves and their families, and they're willing to see the best in other people. I'd like to connect with them.
I want to kind of pivot, and I'm asking this because I don't know how this works. I read a few things. It involves Starlink, and I understand that the FCC recently had a rule where all satellites launched must have a plan to destroy themselves within 5 years. And it's a question of, is that NASA or something? Can you discuss generally the FCC's role when it comes to satellite communications and what the future might look like?
Definitely. So this is something I spent a lot of time on because one of my gripes was that there wasn't enough competition, especially in some of these rural and underserved areas. And so what I was thinking was, oh my gosh, if you could do this from space, that would be a tremendous game changer for some of these communities that either don't have access or only have one provider, DSL or whatever. Historically, satellite had been really low or high latency, which means that there's a huge gap between the time you ping the network and the time you get a response back. And moreover, these old satellite constellations were what are called geostationary. So they send like one massive satellite up and it has to cover, a quarter of the United States. But thanks to advances in technology, what happened by the time I became chairman was that you can now create these really small satellites and send up hundreds or even thousands of them. And you wouldn't have to send them deep into space. You could send them into near Earth orbit, so just outside of the ionosphere, and they could beam back internet access at a speed and a price point that was kind of interesting. But to do that, they needed FCC authorization because whenever they're transmitting to and receiving, they're using spectrum, the airwaves, which the FCC has jurisdiction over. Moreover, historically, the FCC has also had jurisdiction over what's called orbital debris. So if you make a mess up out in space, you've got to clean it up. Those rules had been adopted, when I became chairman, they had been adopted in 2004, I think it was. It had been like almost 20 years since the FCC had updated those rules. And so what we did was to say to Elon and others, we'll authorize all of your low Earth orbit satellite constellations. You can launch, you can use the spectrum. But we also started quite an open inquiry about what should be your obligations in low Earth orbit. Because if you have a collision in space, that stuff could stay up there for thousands and thousands of years. And even like a 1 centimeter piece of material can destroy a spacecraft or another satellite or whatever. And so we didn't want that. Moreover, we wanted to be a good steward in space because we're sharing it with everyone else in the world. And so we didn't want there to be a free-for-all where, China, Russia, others say, hey, if the US is going to do whatever it wants in space, we'll do the same. So we wanted to be sort of a good steward of the space environment. So I'm glad to see my successor at the FCC did bring that across the finish line, and she updated the rules to say you have to deorbit within a certain period of time. These small satellites are really cool devices, but they also burn out quicker than geostationary satellites. So you have to have essentially telemetry and control to be able to tell those satellites, okay, it's been 4 years now or 5 years or whatever it is, you've got to deorbit, and either they have to burn up in the atmosphere or you have to land somewhere that's going to be safe for people on the ground. So I think it's just a good way of making sure that as we emerge into this new space environment, that things are going to be safe both up there and down here.
Where do you see satellite, like low latency, satellite internet like Starlink, and I think there's one more OneWeb? Where do you see those fitting into or competing with 5G, which is more intense, but it's more capital intensive and on the ground infrastructure intensive?
So I don't think it's going to be competitive with 5G, but I can tell you for a fact, because I see it in my current role, it's really competitive now in some of these rural areas. So I visited some places, for example, where all consumers have is like really bad DSL, or they don't have anything at all, or they may have a sort of high latency satellite like Viasat or whatever. But just yesterday, I was talking to a woman who she lives in not upstate, but northern Vermont, and she was telling me that she has Starlink, and it's a complete game changer. She gets 200 megabits per second symmetric at a pretty reasonable price point. I think she pays like 105, which you compare, she was paying more for worse service previously from another provider. And so for those communities, it's a game changer. I don't think it's going to be as competitive where you have, say FiOS or some like really high capacity, lower cost provider, because in urban areas like this, you just don't need that type of, you want faster service, you want higher bandwidth and the like. Starlink just can't scale to accommodate urban areas. But I think in rural areas in the United States, it's going to be a game changer. And what I'm especially excited about is around the world, because we obviously are very fortunate here in the US, but in other parts of the world, forget about wireless service and fixed, and you have nothing at all. And no fiber provider is ever going to reach the rural villages in the part of India where my family is from, but they might be able to access Starlink as those satellites are all orbiting. Those are non-geostationary, so they don't stay in place. They're always orbiting really quickly and create this mesh network in space that theoretically could cover you, whether you're in AU or in Antarctica. It shouldn't matter where you are. So I'm really excited about what this is going to mean for digital opportunity for people around the world, especially in developing countries. Okay.
Can you talk about some of the challenges you faced when you were serving as chairman, but specifically related to like any criminal issues you had to deal with infringements of your rules and government statutes?
Oh, that's interesting. So not really criminal, I can think of. I mean, there are a couple cases where criminal activity leads to the FCC taking away licenses. So for example, if you want to buy a radio station, there was one person who had a domestic violence conviction on his record that postdated his application. And so under FCC rules, you have to have good character in order to own a radio station. So in cases like that, we would have to withdraw the license or not grant it in the first place. There wasn't really, I can't think of any criminal issues as such. I mean, as I said, other than security threats to us, like we had a bomb threat or two, the commission, and so we had to evacuate one.
So how about any broader challenges dealing with pushback or people trying to get around rules?
Yeah, that happened all the time. I mean, I don't even know where to start. Everyone is trying to chisel away and figure out a way to make things work. And so let me think of a good example. Here's a really good example. It's not criminal or anything, but it's sort of I thought it was a pretty chintzy move. So if you provide telephone service, you are required as a company to pay a certain amount of your revenue into what's called the Universal Service Fund. And the USF takes that money and then the FCC spends it on helping people get better connectivity. So every telephone provider has this obligation. If you provide telephone service, you've got to pay into the USF. There was a company that figured out this business model. And if you went on their website, what they would say is, if you buy service from us, what you're essentially buying is two services. You're buying the right to call anybody, and you're buying the right for other people to call you. But you're buying those services separately. And the reason it did that is it argued that under the law that applies this USF contribution requirement, under the law, the FCC was only requiring telephone companies who had bilateral communications capabilities to pay into the USF. So what they said was, look, all we're doing is providing one-way service. Like, we're providing a service to you to call people out, and we're providing a service for other people to call you. We're not providing both at the same time. And so we don't have to pay essentially the tax to the US government. So this is kind of like when I first saw it, I told my lawyers, like, you gotta be kidding me. Like, really? But unfortunately, when these rules were drafted, before I was born, it seemed like the rule, you could make this like plausible argument. I mean, I think it was like a 20% likelihood argument it would succeed in court. But there was an argument that the FCC was a little bit unclear in a couple of the orders about how it applied these regulations. And so I can't even remember what we ended up doing with that, whether we settled or what. But anyway, that was like the kind of thing we would see, like a lot of arbitrage. Many people would come to us saying, hey, look, we've got this great idea for this particular slice of wireless spectrum. So instead of auctioning it off publicly, as you're required to do under the law, why don't you just give us a special, let us have it for free, and we will promise you the moon and stars. Like, we'll use it to provide service to you. All these people who don't have it, and unicorns and rainbows are going to spring from the ground and all this kind of thing. And so we get a lot of arguments like that. Like, you just let us have it for free, and good things will happen. So that's one of the things you get used to in that job, as I found, even more than when I was a commissioner. When you're a commissioner, nobody really pitches you on it because it's really the chairman who sets the agenda. When you're in a corner office, though, everyone comes out of the woodwork. Like, I've got a great idea. All you need to do is X. Or my favorite was always, because I'm a Republican. I'm all in favor of a free market, but in this particular case, like everything that follows the but is like vitiating the entire free market principle we claim to espouse. And so you always have to have your antenna up. And so for any of you who are ever in public service, just always be aware of what your principles are, what the person who's coming to you is looking for, and make sure the two mesh before you make a commitment to a decision.
And then one more quick follow-up.
Yeah.
I've never been able to understand where the different frequencies kind of originate from.
Yeah.
Could you just kind of talk about that for a minute? It's something hard to wrap my head around.
Yeah, it's just the basic physics. So right now, for example, we are talking at about like a 20 hertz or 30 hertz frequency, depending on how high or low your voice is. But telephones or wireless phones can operate at all kinds of different spectrums. So our AM radio is operating in the hundreds of hertz. FM radio is like in the thousands of hertz. And then once you get up to the megahertz, so 1 megahertz is 1,000 hertz. Then you have wireless spectrum that can be used, and so it really spans all over the place. So generally speaking, there's a rough rule of thumb that below 1,000 megahertz is below 1,000 hertz, below 1 megahertz is radio. From 1 to 3 is sort of traditional wireless communications. From 3 to 7 is a mix of wireless and Wi-Fi. So the Wi-Fi spectrum that you're using is typically either 2.4 gigahertz, which is 2,400 megahertz, or 5 gigahertz. I don't know if you have been to like a Costco or Best Buy or anything like that recently. If you see a Wi-Fi 6 router or 6E router, that's using 6 gigahertz spectrum, which we authorize, by the way. But that's also that 3 to 7 range, I would say. And then above, from 7 to 12 is a mix of stuff. Like some of it is satellite. 12 is satellite. There was a question about satellite. That's Elon and others are using that for Starlink. And then there's a whole mix, like above 12. It's kind of a free-for-all. Like from starting at 24 gigahertz is what's called millimeter wave spectrum. The spectrum travels very short distances, but provides a lot of capacity. So some people are using it for short-range communications. And then one of the last things we did before I left was to tee up what we're called terahertz. So it's like a million hertz, I guess it is. Because all these scientists that we were talking to said, hey, it sounds crazy, but for like micro communications, machine-to-machine communications, you could see a future where, like using AI, all of these machines are talking to each other. They need a massive amount of spectrum over short distances. You should think about this terahertz stuff, which sounds crazy, but on the other hand, Wi-Fi spectrum was thought of as crazy back in 1999 when the FCC authorized it. It was actually called a junk band, 2.4 gigahertz band, because no one wanted it, no one thought it could be used for anything, and just imagine our world without Wi-Fi now. It's unthinkable. So that's, we kind of open it up for entrepreneurs to play around with, and you have Wi-Fi today, and that's what we're hoping terahertz will be in time to come. So we shall see.
Interesting. Thank you.
Yeah.
Oh, actually, were there any practices you developed in in law school that you still use today or
Oh,
that
wow.
contributed to your success?
Well, certainly, kind of being, having a great attention to detail / being a dork about like trying to figure out the particulars of a legal question it's been very helpful to me. Even my current role too, like trying to figure out, what is a court likely to do on X? You really have to study the law and have an informed view when you're presenting to our internal committee about what that position is. I guess honestly, just, like really hard work. We were talking earlier about the work you're doing on judiciary. Like just get into the grind, and it may be boring sometimes. Like you may not think you're learning all that much, but over time, it has a real incremental effect, and sort of like compound interest. Except in this case, the compound interest redounds to the benefit of your career. People will notice that; they're going to remember you, and that proved so valuable to me in my career. Early on, I worked for when I was at Verizon. I worked for the general counsel and really tried to bust my hump to do a good job, and he recognized that. And then went immediately thereafter to Capitol Hill, where I worked for a senator who recognized that as well. And that happened to be Bill Barr and Jeff Sessions, who became 2 attorney generals of the United States. Like that helped me quite a bit throughout my career, obviously. And but similar things like that. The other thing I would say is just I didn't do as good a job of this in law school, but they didn't teach us this in law school. But really try to get to know people who are in your field of interest as best you can. It sounds obvious, or it might sound irrelevant. You should be able to get a job or whatever, or succeed based on the merits of your legal analysis alone, and how sterling your legal writing skills are. But in reality, a lot of these jobs are going to become apparent to you because someone told you about it, something you knew, and so, or sometimes they'll just think of you without you even knowing about it. So just network as much as you can. That really helps a lot. And I guess the other thing that's really helped as well, although not professionally, but just more personally, is again, very obvious, but just try to be a good person and be the person you are. It's just yesterday at the airport, I ran into a law school friend of mine. He was my editor on Law Review when I was a second year. He was a third year. Really nice guy, and he and I spent many hours in the library talking about site checks and all of this. But he always remembered me as like being a friendly individual. So when I saw him yesterday, like, we gave each other a hug. It's just sort of those types of interactions that are going to carry you through when your career gets difficult and when life is challenging. And all things being equal, I'd much rather be known as like a hardworking person who is nice as opposed to a hardworking person who's a jackass. And the former approach is one that's going to pay more dividends to you personally over your time. Law school. Gosh, it's been so long now. I don't really remember it anymore, but I remember some cases and whatnot. But it's I don't know. It's more those general lessons that appeal to me over time.
Thank you.
And you're so lucky that you're here in DC too. Like we were just mentioning earlier that just to have proximity to Capitol Hill and all the agencies in the White House, like you're so lucky. I didn't have that in law school. I didn't even know that it was possible. So you've already got one step on me.
So, big question.
Yeah.
So
Major question.
what should be done about Section 230? Because on the Hill, nobody likes it, but we can't agree on how to change it.
Yeah.
So what should we do?
So my own position, I think, this is tentative, is that the Justice Thomas view should prevail. That it's up to a court to more narrowly interpret Section 230.